Victoria v. Commonwealth, 45 Australian Law Journal, 251 Amalgamated Society of Engineers, v. Adelaide Steamship Coafta, 1920, 2S CLR 129, Moore if or SV. Attorney General for the Irish Free State, Inarsu Gel 935, AC 484, Leonage v. Queen, 1967, LAC 239, Kapoor case, 1968, AC 71, Ranasinghe CSC, 1965, AC, 172 Elberg Klebe case, 1964 AC, 900 ex-claimed and held math cable. The word amount in Article 31-2. After the 25th MEDMCNT means sum of money, the principle which Tinehi acted upon the legislature tn fixant t, Jayamulaf TMLFI include considerations of social justice. Farani Kesavananda Bharati. 31 ill and Part JV of the Constitution touch and modify each other. The 80 quasi of amount fixed on the principles specified or the manner as, to host CV, such amount is to be given otherwise than in cash, and not be the subject matter of judicial review. Article 31.2 is self-contained, and Articles 31.2 and 19.1 F are mutually exclusive. Article 31.2 is to be read with Articles 31A, 31B and 31C's. Article 31C is an application of the Prince J. Plis underlying article is 31.4 and 31.6 and 31A to the sphere of industry. The article creates a legis J-evaluative field with reference to the object of legislation. In removing restency of Part ill in respect of a lay TV on DTR Article 31C, there is no delegation of any power to amend the Constitution. Courts can go into the gestion, heth. Our legislation containing a declaration has nexus TVT, the directive prenuptials in Article 39B and C. The framers of the Constitution envisaged social structure which would avoid the acquisitive economy of private capitalism and the regimentation of totalitarian state. The Constitution was framed with the object of effecting social revolution, and the core of commitment to social revolution lies in Part ill and Part 4 of the Constitution. The directive principles are also fundamental, and they can be effective only if they are to prevail over the fundamental rights of a few in order to subserve the common good and do not allow the economic system result in the common detriment. A fundamental right may be regarded as fundamental by one generation. It may be considered to be inconvenient limitation upon legislative power by another. Popular soikranti means that the interest which prevails must be the interest of the mass of men. If rights are built upon property, those who have no property will have no rights. Therefore, the state has to balance the interest of the individual with the interest of the society. 41, 445. The word amount in Article 31.2, after the 25th Amendment, is to be read in the entire collocation of words. In Article 31.2, the use of the word amount in conjunctiven with payment in cash show, vs. that a sum of money is being spoken of. The quantum cannot be a matter of judicial review if the legislature docs not fix the amount but specifics the principles for determining the amount. The relevancy of the principles cannot be iron-punned, nor can the reasonableness of the principles be impeached. Any attempt to find out, as to v. the particular amount is fixed or how that amount has been fixed by law will be examining the adequacy which is forbidden by the constitutional M2 ill date. The quantum of the amount, if directly fixed by the law and the principles for its quantification arc, matters for legislative judgment. In fixing the amount, the legislature will act on the general nature of the legislative PDY. The principle which may be acted upon by the legislature in fixing the amount may include considerations of social justice, considerations of social justice. Will inc1j.dc the relevant directive principle, particularly under Article 39b, and c. Article 19.1. C is excluded from Article 31(2), M order to make Article 31(2) self-contained. The right to hold property cannot coexist with the right of state to acquire property. That is why Article 31(2) is to be read with Articles 31A, 31B, and 31C, all the articles being under the heading right to property, P plus 17, 448. There was no flexibility of social interest in Article 31(2) as it originally stood. Every .cn CCPT of social interest became irrelevant by the scope of Article N2 term. It is this mischief which was sought to be remedied by the 25th Amendment, Part the 3rd, N, DIF of the Constitution touch. Arid modify each other, they are L, parallel to each other. Diffulcrant legislation will bring in different social principles, TC will not be permi. L without social content operating 32 supremacool, T repox FL973J sup, SCL in a BexBL. Manner. That is why in the 25th Amendment Article 31.2 is dead to M8 the concept of market value, or PR Tilden. D. OPCR Wu. 11 acroyojer requisance of compensation TNCNs an amount de RD. F social. TI the NUC 11B. AMI on PRMC1 Piezo Juice Key Air WI General Harmony.